Hi there, this is Jonathan Ginsberg. I'm a personal bankruptcy attorney here in the Atlanta area. And today I'd like to talk to you about what you can do if you have an unexpected wage garnishment, a wage garnishment emergency, for lack of better terms. And basically what's happened is that somebody has gotten a judgment against you, and they've taken that judgment, they've made it into what's called a FIFE, and they've gone to your employer and said, withhold a percentage of this person's wages. And the employer is required to withhold 25% of your disposable pay and send it in to the plaintiff, to the judgment creditor. If they don't do it, by the way, then the employer becomes responsible for the full balance. So employers have a very, very strong financial interest in complying with a wage garnishment. Now, I can't tell you how many times people have told me over the years, I had no idea. First time I heard about this wage garnishment, a judgment, was when my employer said, I got this notice of continuing wage garnishment, and what can I do? Well, first of all, I'll tell you that again, with wage garnishments, the first thing that has to happen is there has to have been a judgment. So if you ever got a document handed to you by a sheriff's deputy, that's a lawsuit, and you should always take action on that. If somebody in your family got some papers from somebody in a uniform, that probably means you were sued. Check your credit report periodically to see. That will also tell you, and annualcreditreport.com is where you can get your credit reports for free. That will also show you if you've been sued. And if you've been sued, that's a warning sign. That's a big red flag that your wages could be subject to garnishment. Now, I will tell you that there are some instances where people are sued in another state. Some credit card agreements say that you consent to what is called venue for a lawsuit in another state, New York, California, Nevada. And that lender can sue you in Nevada, and theoretically they're supposed to give you notice, but sometimes it doesn't happen. They get their judgment in Nevada, and they domesticate it here in Georgia, and the next thing you know, you're being garnished. And there are some ways out of that. There's challenges to that, but again, if you don't have a lot of money, finding a lawyer to do what is called a collateral attack on that judgment, it's going to be very expensive and time consuming. Sometimes bankruptcy is an easier route. And basically what we can do if we get a bankruptcy filed is we can get the automatic stay created. The automatic stay stops the execution of any wage garnishment, and in some cases I can even get the money back that's been withheld if it hasn't already been sent in. The key is the minute you find out that there has been a lawsuit against you, that there is a judgment creditor out there, talk to a bankruptcy lawyer, because we need to know as soon as possible that there's a potential problem here, and confirm that in fact it's a legitimate judgment. I've had a few times where the judgment was not legitimate. It was not served on my client properly. It was served on somebody with the same name, but not my client, and we were able to get it undone informally without having to go through bankruptcy. So the sooner you know about that, you can talk to your attorney about it, the better. But the bottom line is, if we need to file bankruptcy, we can do an emergency bankruptcy petition that normally is going to take about a day between the time you get your credit counseling certificate and get the filing fees and attorney's fees paid and get the paperwork signed. We can get it filed within a day or so, and that will stop the ongoing garnishment. So bottom line is, as soon as you know about this potential problem, the sooner you get to my office, get to an attorney's office, the sooner we can take emergency remedial action, stop the wage garnishment, get your money back, stop you from losing any more money, and giving you a chance to reorganize, at least figure out what's going on. And there have been a few cases I've been in when, again, it turns out that the garnishment was not proper. We end up dismissing the case or working something out. So there are some options there. But bottom line is that don't wait until after the garnishment's run for a few weeks and say, maybe I ought to talk to a lawyer. As soon as you hear there's a problem, you sense there's a problem, get on the phone, pick up the phone, call me. Let's figure out what we can do about it. So hope you found this video helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook. If I can be of assistance to you, please call me or Susan Bloom in my office, 770-393-4985. We'd be happy to help you any way we can. Thanks a lot.